Now starting. All attendees are in listen-only mode.
Hello everyone and welcome to today's session, Impact of TLOA and VAWA. I'm Travis Johnson, your moderator for today's session. We are joined by Michelle Parks, the Associate Director of Tribal Judicial Institute at the University of North Dakota School of Law, and by Mr. Julius Dupuy, Policy Advisor with the U.S. Department of Justice, Bureau of Justice Assistance, who will be doing a brief welcome. A recorded version of this webinar will also be made available on YouTube later, if you have to leave early or want to share with a coworker. You can find this link in the APPA Tribal Repository website. We'd love to hear from you. Feel free to post your questions throughout the session, and we will designate the last 15 to 20 minutes or so to respond to your questions. For those of you who have just joined us, welcome. I'd like to introduce today's speaker. Ms. Parks is a licensed attorney in the state of Illinois and the United States District Court for the District of North Dakota. Ms. Parks is an appointed member of the North Dakota Supreme Court State and Tribal Court Committee. In January of 2011, Ms. Parks was appointed by U.S. Attorney Eric Holder to serve on the U.S. Department of Justice Violence Against Women Federal and Tribal Prosecution Task Force. Ms. Parks served as the Chief Prosecutor for the Spirit Lake Nation for approximately 4 years and served the tribe as the tribal attorney until the fall of 2012. Ms. Parks has background in training and educating at the tribal, state, and federal law enforcement agency levels on a variety of topics relating to the practice of both tribal law and federal Indian law. In 2008, Ms. Parks was appointed as a special judge in the Turtle Mountain Band of Chippewa jurisdiction, and in 2015, Ms. Parks was appointed to serve as the Chief Justice of the MHA Nation Supreme Court. Ms. Parks also serves as affiliated faculty at UND School of Law, having taught courses on federal Indian law, tribal economic development in the law, and tribal law. Additionally, in 2003, Ms. Parks was hired to serve as a tribal justice specialist for the Tribal Judicial Institute to provide technical assistance to tribal courts in conjunction with the grant from the Bureau of Justice Assistance. In 2005, Ms. Parks became the Associate Director of Tribal Judicial Institute at UND School of Law, where she continues to provide training and technical assistance to tribal, state, and federal officials, judges, and personnel on topics relating to the planning, implementation, and enhancement of tribal justice systems. Ms. Parks has extensive experience working with tribal elected officials, tribal and state judges, tribal court personnel, social service programs, victim advocacy programs, and other tribal justice officials in the area of tribal justice system planning, program development, economic development, business law, code development, child welfare, sex offender prosecution, and management of domestic violence. We're also joined by Julius Dupuy, who is currently a policy advisor within the U.S. Department of Justice, Bureau of Justice Assistance. He is responsible for overseeing and managing projects that provide financial and technical assistance resources to the criminal justice field. His area of focus include the Tribal Justice Infrastructure Program, Prison Industries Enhancement Certification Program, Tribal Reentry, Tribal Community Supervision, Capacity Building, and other efforts that focus on strategies to assist states, localities, and tribes with justice improvement efforts in the rehabilitation of justice-involved individuals. Prior to working for BJA, Mr. Dupuy was a program manager with the Office of Justice Programs, Drug Courts Program Office. In 1996, he began working for the Department of Justice as an employee with the Office of Community-Oriented Policing Services. We will now begin our session, The Impact of TLOA and VAWA. It is a great honor to introduce our first speaker, Julius Dupuy.
Thank you, Travis. On behalf of the Bureau of Justice Assistance, I would like to thank you all for your interest in today's webinar. I'd just like to start by giving a little bit of background on both TLOA and VAWA. In 2009, Department of Justice officials heard from tribal leaders about the pressing need for federal legislation and financial resources to help tribal public safety officials better address the problems facing their communities. Justice officials learned about the disproportionate rates of violence and victimization in tribal communities and about the need to improve government-to-government collaboration and provide improved access to law enforcement and justice resources. In response to this message from the tribes, the Tribal Law and Order Act was signed into law on July 29, 2010. The Tribal Law and Order Act helps to address crime in tribal communities and places a strong emphasis on decreasing violence against American Indian and Alaska Native women. The Act encourages the hiring of more law enforcement officers for Indian lands and provides additional tools to address critical public safety needs. Specifically, the law enhances tribes' authority to prosecute and punish criminals, expands efforts to recruit, train, and keep Bureau of Indian Affairs and tribal police officers, and it provides BIA and tribal police officers with greater access to criminal information sharing databases. It also encourages the development of more effective prevention programs to combat alcohol and drug abuse among at-risk youth. Another important law enacted to enhance the authority of tribes and enforce criminal regulations and protect public safety is the Violence Against Women Reauthorization Act of 2013, or as it's also called VAWA 2013, which was signed into law on March 7, 2013. VAWA 2013 recognizes tribes' inherent power to exercise special domestic violence criminal jurisdiction over certain defendants, regardless of their Indian or non-Indian status, who commit acts of domestic violence or dating violence or violate certain protection orders in Indian country. Now, during today's webinar, you will hear about how these major legislative reforms have impacted tribal justice system processing and community reintegration efforts for individuals returning home from detention facilities. This webinar is being hosted by the American Probation and Parole Association. They're BJA's primary tribal community supervision and reentry training and technical assistance provider. For more information regarding available TTA resources, please contact Nan Benally. She's the Tribal Program Grants Manager, and then she could be reached at nbenally@csg.org, or her phone number is 859-244-8056. And her information is also on our Tribal Justice and Safety Training and Technical Assistance webpage as well. And that webpage, actually, you can also find our latest funding opportunities. The Bureau of Justice Assistance has a number of open available funding opportunities out right now. Some focus on Second Chance Act. We recently released an opioid-related solicitation within the last day or so. So I encourage you to visit the Tribal Justice and Safety website to hear more about those opportunities. And actually, you would go to www.usdoj.gov/tribal, and then our homepage would come up, and then you would see a link for BJA funding opportunities. And with that, I'd like to go ahead and hand it over to Michelle Parks.
Thank you, Julius, and thank you, Travis. Welcome, everyone, to today's webinar. We're going to be talking a little bit today about the impact of the Tribal Law and Order Act and the Violence Against Women Act on tribal justice systems. What we are going to be specifically discussing today at first will be to introduce you to the Tribal Law and Order Act of 2010 and its impact on justice systems. Specifically, we're going to be talking about the enhanced sentencing authority that was included as part of that act. We are also going to discuss Title IX, the 2013 Violence Against Women Act reauthorization, and its impact on tribal justice systems. More specifically, we will be speaking to the special domestic violence criminal jurisdiction provisions of that particular law. As we discuss the impact on tribal justice systems, what we will focus on are the rights of defendants in tribal courts and how those have been impacted by these two important pieces of legislation. We will be talking about sentencing and sentencing authority in tribal courts. We will speak to the classification and prosecution of felony crimes and crimes in tribal courts. Additionally, we will touch upon judicial and attorney qualifications, as well as the impact that these two laws have had on post-adjudication services, such as probation and reentry. So let's first introduce you to the Tribal Law and Order Act and the Violence Against Women Act, specifically the enhanced sentencing authority of the Tribal Law and Order Act and the Special Criminal Domestic Violence Jurisdiction of the Violence Against Women Act. The Tribal Law and Order Act of 2010 was signed into law July 29th of 2010. The Tribal Law and Order Act sought to accomplish several ends, including clarification of governmental responsibility to prosecute and hold individuals accountable for crimes that are occurring in Indian country. The Act itself also sought to increase and improve collaboration among federal, state, and tribal justice system officials. It also purported to support tribal self-governance, to reduce violent crime in Indian country, and also to support the collection of data and data sharing among jurisdictions. And as Mr. Dupree had stated during his introductory remarks, the Tribal Law and Order Act was the culmination of a series of discussions with tribal leaders and justice system officials. So one of the things that was included within the Tribal Law and Order Act to achieve some of these stated goals were provisions that specifically addressed sentencing authority of tribal courts. Specifically, Section 234 of the Tribal Law and Order Act amended the Indian Civil Rights Act, which can be found at 25 U.S.C. Section 1302. These amendments expand authority to impose longer sentences and fines for qualifying offenses. And later on in the webinar, we'll speak a little bit about what qualifying offenses are. So prior to the Tribal Law and Order Act of 2010, the Indian Civil Rights Act limited tribal court sentencing authority to a maximum sentence of 1 year, a maximum fine of $5,000, or both for a conviction in tribal court. And even if a tribe was to prosecute or an individual of what we might otherwise consider a felony level crime, such as a homicide or a sexual assault, the tribal courts were still limited to that 1 year sentencing authority and that maximum fine authority. After the enactment of the Tribal Law and Order Act and today, what we have is enhanced sentencing authority in tribal courts. So at this point in time, for those tribes that qualify, sentences of up to 3 years with a complete max of 9 years for imprisonment and $1,000 or both may be imposed for certain qualifying offenses or qualifying crimes. And again, we will talk about this a little bit further into the webinar. Now, it's important to note that not all tribal courts are currently prepared to impose enhanced sentencing authority, and some may have opted not to. For those that are prepared to impose enhanced sentences and that have opted to do so in the interest of the justice system, the Tribal Law and Order Act, Section 234, required that certain protections of defendants' rights be in place within the tribal justice system. And to that end, the Tribal Law and Order Act also amended the Indian Civil Rights Act at Section 1302A, 13027, 1302B, C, D, E, and F. So within those provisions of the Indian Civil Rights Act, you will find the specific rights that must be in the event that the tribe is attempting to impose an enhanced sentence on an individual who is appearing before the tribe's criminal court. So as stated, Tribal Law and Order Act Section 234A3 amended the Indian Civil Rights Act specifically at Section 1302C. And the provisions on this particular slide are the rights of defendants as you will now see them in the Indian Civil Rights Act. And if a tribe is wanting to impose a sentence of more than 1 year of imprisonment. In that situation, a tribe must afford an individual defendant effective assistance of counsel, at least equal to that guaranteed by the U.S. Constitution. A tribe must also provide indigent defense, and that indigent defense must be in the form of a licensed attorney that is provided at no expense to the defendant in the event that they meet status. It also requires that the presiding judge in the case have sufficient legal training to preside over the proceedings and be licensed to practice law in any jurisdiction in the United States. Further, the tribe must make criminal laws publicly available prior to charging the defendant, and those laws that are publicly available must include rules of evidence, rules of criminal procedure, and rules pertaining to recusal of the judge. Now, the law itself, or the civil rights, didn't specifically prescribe how these laws need to be made publicly available, but what we're seeing in a sort of a trend across many tribal communities is that laws are being made publicly available via websites and other online forums. But there are a number of ways that a tribe might be able to meet this public availability requirement. Also, the tribe must maintain a record of the criminal proceeding, and when maintaining a record of the criminal proceeding, the tribe must include an audio or recording. Another law that has impacted tribal justice systems, as we talked about, is the Violence Against Women Act of 2013, or the VAWA reauthorization of 2013. Specifically, Title IX, Section 904, addressed tribal criminal jurisdiction over crimes of domestic violence that are occurring within Indian country and that are being perpetrated by non-Indians. Section 904 amends the Indian Civil Rights Act to include special domestic violence criminal jurisdiction over non-Indians for acts of violence that occur in Indian country, for acts of dating violence that occur in Indian country, and for protection order violations that occur in Indian country. Furthermore, Section 905 of the Violence Against Women Act reauthorization addressed tribal protection orders and sought to clarify the authority of tribes to both issue and enforce qualifying orders of protection. Prior to the VAWA reauthorization of 2013, there was some disagreement among jurisdictions as to what the nature and extent of a tribe's ability to enforce an order of protection was, especially if a violation occurred in Indian country at the hands of a non-Indian offender. For tribes that are wanting to exercise special DV criminal jurisdiction, the law also requires that specific rights to defendants be made available for qualifying crimes. And you're going to see some consistency in the language between the Tribal Law and Order Act and the VAWA with respect to qualifying crimes and the rights of defendants. And I would like to just make a note here that with respect to the sentencing authority and the ability of tribes to prosecute non-Indians, there is a long history of Supreme Court analysis in a number of different cases wherein concerns were raised as to how individuals would be treated in tribal courts, what rights were afforded to tribes or to individuals in tribal courts, and that the rights that are provided or were historically provided in tribal courts may or may not have met U.S. constitutional standards. And so there was some reluctance, if you will, on the part of the U.S. Supreme Court to acknowledge any jurisdictional authority for tribes over non-Indians because of some of those differences in the specific rights of defendants under the U.S. Constitution and under the Indian Civil Rights Act. So, back to Section 1304 of the Indian Civil Rights Act, that was amended by the Violence Against Women Act with respect to this special criminal domestic violence jurisdiction. And what Section 1304 did was to provide some specific definitions, such as the definition for dating violence, to name one, that would be applicable in this particular type of jurisdiction. Very important to tribal courts also is that there was language included that these amendments were intended to reaffirm the inherent authority of tribes to address these kinds of crimes. Now, when we look back to some of the U.S. Supreme Court precedent, a specific case, actually it's United States versus Lara, addressed the distinction between the inherent authority of tribes and an exercise of a delegated authority. If there's a delegated authority, then we can run into some issues of double jeopardy if both the tribe and the feds were to prosecute crime. However, with this specific inclusion in the Violence Against Women Act reauthorization, Congress was very clear that they were intending to reaffirm inherent authority of tribes to address crimes, thereby leaving open the opportunity for the exercise of concurrent jurisdiction between federal and tribal authorities for domestic violence related crimes. Section 1304D specifically addressed the rights of defendants that would attach to prosecution in a tribal court if the prosecution was a special domestic violence jurisdiction case. So in the context of violence against women and the special domestic violence criminal jurisdiction, the VAWA amended ICRA 1304D specifically to afford very concrete rights to defendants in these types of cases. One of the things that these provisions did was to attach all of the applicable rights under the larger Indian Civil Rights Act, also to include and attach any of the rights for defendants that might apply in an enhanced sentencing case, as we just discussed, and also added that there was a right to a trial by an impartial jury that is to be drawn from sources that reflect a fair cross-section of the community, that do not systematically exclude any distinctive group in the community, including non-Indians, and all other rights whose protection is necessary under the Constitution of the United States in order for Congress to recognize and affirm the inherent power of the participating tribe to exercise the special domestic violence criminal jurisdiction. So let's recap. That was a lot of information with respect to the legislation and the rights of defendants. But these specific rights of defendants, and part of the reason that we want to focus on this, is that these changes to the Indian Civil Rights Act with respect to defendants' rights have a greater and larger impact on tribal justice justice system, as well as collaboration and communication among jurisdictions. So as a recap, under the Tribal Law and Order Act, if an enhanced sentencing authority is being exercised, the tribe must provide the defendant with effective assistance of counsel. They must provide the defendant with indigent defense, meaning that if an individual is income eligible and cannot afford an attorney, one would be provided to them at no expense, and the attorney must be licensed by any jurisdiction. The judge also has sufficient legal training and be licensed by any jurisdiction. The criminal laws, rules of evidence, and rules of procedure must be made publicly available, and a record of the proceeding must be maintained. Now, if a tribe is to exercise the special domestic violence criminal jurisdiction, the tribe must provide all of the rights that are outlined in the Indian Civil Rights Act at 1302C, which are those that we just went over and apply to enhanced sentencing authority. And they must also provide a trial by an impartial jury, and a jury that is drawn from a source that will reflect a fair cross-section of the community and does not systematically exclude a distinctive group. Now, the changes to the jurisdiction of the tribe with respect to the individuals over whom they may exercise jurisdiction, as well as the enhanced sentencing authority of tribes, that it directly impacted and continues to impact the way that tribal justice systems are developing moving forward. And so we want to talk a little bit about some of the implementation considerations that tribes are taking into account. So when these laws were first enacted, the tribes had to discuss and consider whether or not to implement or not to implement. And that included the enhanced sentencing authority from TLOA. It also included the domestic violence jurisdiction. Important to note is that the Tribal Law and Order Act provisions did not come with specific set-aside funding for tribal justice systems to implement. Now that's not to say that there is not any source of federal fundings to help tribes that are wanting to provide licensed attorneys or trained judges. It's just that the funding sources were not specifically included in the Tribal Law and Order Act. But there are many opportunities through Bureau of Justice Assistance and other DOJ programs and BA programs that tribes might access. But the funding was an important consideration for many tribes, especially when looking at the need to fund a criminal defense program and with the requirements that attached to the judges. Many tribes have opted to contract with attorneys on a part-time basis, especially if they are finding that they are not having to adjudicate many cases involving enhanced sentencing or special criminal domestic violence jurisdiction. The contract may provide with a less expensive means to be able to meet the requirements of the laws. Some tribes are contracting with legal services organizations and fulfilling the legal requirements in that way. Some tribes are opting to hire full-time public defenders, and in some cases, they may even be utilizing this as an opportunity to develop an entire public defense office and program. And for those tribes that are doing that, we're seeing that many of those public defense offices are providing defense counsel in ESA or enhanced sentencing authority cases, special criminal domestic violence jurisdiction cases, and in some instances they are also providing services in other crimes in the tribal court. Also, with the judicial qualifications, some tribes are finding that it has been difficult for them to be able to financially compensate licensed, law-trained judges. And so they are also looking at similar part-time contractual opportunities to ensure that the presiding judge in the enhanced sentencing authority cases, LDV jurisdiction cases, meet the new legislative requirements. And I'm also going to add here that another factor that tribes considered and are continuing to consider in whether or not to implement the ESA authority or the special DV criminal jurisdiction are some of the detention costs that might also attach to these cases. We know that detention is not free, and it is a cost, a daily cost typically. So access to detention and detention costs has also been a factor tribes are considering. And then post-adjudication costs for probation and post-sentence monitoring is another area that tribes are looking at. Now, some tribes already have probation departments. Some are, again, using these pieces of legislation as an opportunity to develop and implement those types of programs and services, and other tribes are maybe finding that they are not currently prepared to create those types of programs, but maybe looking to do so in terms of a longer justice system planning process. Now, in addition to the factors relating to the costs or the the financial considerations with implementing ESA or special DV criminal jurisdiction, tribes also needed to take a look at and consider what, if any, code amendment or development would be required in order for the tribe to be able to fully implement enhanced sentencing authority or the criminal jurisdiction for domestic violence qualifying cases. And specifically, as tribes were looking at this, they were looking at provisions within their law and order codes that applied to legal counsel or the provision of defense counsel. They may have also considered whether there were any defendants' rights provisions within their laws or codes that needed to be updated or otherwise amended. Also looking at judicial provisions within codes and reevaluating what the qualifications for judges would be within their tribal courts is something that was being considered and continues to be looked at by those tribes that are considering ESA or the special DV criminal jurisdiction. Looking at what the terms bail or pretrial release would be to make sure that the provisions in their codes were not going to be something that would be considered excessive. And then also taking a look at the criminal provisions of their codes that applied to sentencing restrictions with respect to jail time and fines, and whether those needed to be amended or otherwise changed, and to ensure that there was nothing in the tribal code that would be considered cruel or unusual. Although, in complete fairness, I would say at this point in time, we're not going to find cruel and unusual punishment in any of the tribal codes that I have reviewed. So I think the bigger factor in looking at the remedies provisions of tribal codes was that the tribal code was not being overly restrictive and would allow the judge to impose the enhanced sentencing authority. And I'm going to add to that too, with the tribal code amendment and development, there is the matter of just looking at the code and doing a tribal code assessment, identifying the needs to develop or amend tribal law, but also there were factors to be considered in terms of the time constraints for changing tribal code. Of course, vary from tribe tribe, and then the costs associated with hiring or assigning personnel to work on that particular task is another factor that tribes were considering in whether or not to implement ESA or the special DV criminal jurisdiction. Now, lastly, I think that what we have seen also in terms of feedback from tribes and factors that they're considering in whether to implement or not to implement TLOA, Enhanced Sentencing Authority, or the VAWA Special DV Jurisdiction is really views inherent authority. And although the stated intention of the Tribal Law and Order Act was to reaffirm and to support tribal self-determination, and the Violence Against Women Act very clearly included provisions that reaffirmed the inherent sovereign authority of tribes. Some tribes felt and continue to feel that these laws may run contrary to inherent tribal authority. And in part, some of the tribes that are expressing this are the treaty provisions, if they have a current treaty with the United States government, and some of the provisions of those treaties that may rest some of the responsibility for holding individuals accountable for crimes with other jurisdictional authorities. Also, I think that some of the concern or reluctance within parts of Indian country has been that the Tribal Law and Order Act itself was one that doesn't address the case of Oliphant versus Suquamish. And for those of you not familiar, Oliphant versus State Supreme Court case, which in a very reduced statement held that the tribes lack criminal jurisdiction over non-Indians. And I think for many tribal justice system officials, people have been calling for an Oliphant fix, if you will, for many, many years. And I think there was some frustration, if you will, that the Tribal Law and Order Act was not able to address a specific Oliphant fix. The Violence Against Women Act does address the Oliphant versus Suquamish, but in a very narrow manner, because it does recognize the authority of tribes to prosecute non-Indians, but only with respect to qualifying domestic violence cases and qualifying violations of qualifying orders of protection. So these are kind of some of the considerations that tribes are looking at in deciding for themselves whether or not it's best for their tribal justice system to impose enhanced sentences or to prosecute non-Indian offenders of domestic violence in their tribal community. Okay, so once tribes have kind of had the internal discussions, and for those that have decided to implement the Tribal Law and Order Act Enhanced Sentencing Authority and the Special DV Criminal Jurisdiction, there are several considerations for change that need to be taken into account in terms of the impact that these particular laws will have on both crime in the tribal community and the way that we address crime through our tribal justice systems. And I want a moment just to draw your attention to the Violence Against Women Act 2013 Special DV Criminal Jurisdiction 5-year report that was released in March of 2018. And I think for those of you that would like to find a copy of that report, I believe that you can find that on the National Congress of American Indians website. You may also be able to find that on a federal website within the Department of Justice, probably through the Office of Violence Against Women. One of the 5-year report has done was to take a look at the number of tribes that are currently opting to exercise the special DV criminal jurisdiction. And as of March 2018, 18 tribes in the nation have opted to exercise this jurisdiction, and those 18 tribes are located in 11 different states. For those tribes, among those 18 tribes, there was some data collected as part of this report to look at the number of arrests on Indians that have taken place within those jurisdictions since the special DV criminal jurisdiction has been exercised. The report demonstrated that there had been 28 arrests of non-Indian, sorry, I don't think that's actually correct. I think I may have, I think that's a higher number. I apologize. Because we have 74 non-Indians who have been convicted under the special DV jurisdiction. We have 5 non-Indians who have been acquitted, and there are currently 24 cases pending in these that have yet to be formally adjudicated. What's been interesting and what was disclosed in the report is that once a tribe exercises this special DV criminal jurisdiction, if a non-Indian feels that the tribe lacks jurisdiction over them or they are being unlawfully detained, their remedy is to seek a habeas petition in federal court. And according to the report, of those tribes that are exercising the jurisdiction, there have been no reported cases of non-Indians seeking habeas relief in federal court. So that's promising, and I think a demonstration to the quality work that's being done in those implementing jurisdictions. Now, what we don't know in terms of the impact of TLOA, Enhanced Sentencing Authority, and the VAWA, I would say comes in terms of more qualitative research relevant to the impact of the exercise of the jurisdiction on crime rates and recidivism. So we're kind of at a point where we're able to collect some of the data and information that is relevant to number of arrests, convictions, things of future. But I think what's going to take a little bit more time is to see how many of those individuals are then reoffending within the tribal community. So we'll stay tuned for that, and I suspect that we are going to see that kind of data coming out into the future. So outside of kind of some of the data or the statistical information coming out of the Violence Against Women Act, and sort of this lack of data to varying degrees on enhanced sentencing authority at this point, what we do know is both the Law and Order Act and the Violence Against Women Act have specifically impacted tribal justice system development, and they have also had an impact on how we're collaborating and communicating among state, federal, and tribal justice systems. And if you'll recall from earlier in today's presentation, improved communication and collaboration was one of the stated purposes of the Tribal Law and Order Act specifically. In terms of collaboration, I think we're seeing a lot of discussion in the area of post-adjudication services, especially with respect to detention, reentry initiatives, and probation and supervision. And we're going to talk about those a little bit more here. So when we're looking at the impact on tribal justice systems, we want to talk a little bit about the practical impacts as opposed to kind of that statistical data. And when we're looking at the practical impacts, one of the areas that we've seen impacted specifically pertains to attorney and judicial qualifications. So we're at a point now where we're hiring licensed attorneys to provide or serve as defense counsel. And this is a change for some tribal justice systems, you know, especially those that may be more rural in terms of demographics, with less access to professional attorneys. There's been a long history of advocates being used both for prosecution and defense in many tribal communities. And many of those advocates have, a degree of law training, whether that be continuing legal education or perhaps it's experiential learning over a period of 20 plus years. And I want to emphasize that the use of advocates in tribal courts continues to be something that is done and is perfectly fine if it's working for the tribal court. However, if the tribe is moving forward with enhanced sentencing authority or special DV criminal jurisdiction, then those licensure and training requirements become a little bit more stringent. Also, with respect to judicial qualifiers, there's also some requirement of law-trained judges, and for some tribal communities, the codes may have only required that the judge be an enrolled member, meeting age requirements, and perhaps have a familiarity with the laws of the tribe. But now there's been some change, or at least some emphasis on tribes revisiting judicial standards for licensing and professionalism, at least in those cases where special DV jurisdiction or enhanced sentencing is being implemented. Jury impacts are another area where we're having a lot of discussion, and I would say this is also an area where we're seeing discussion being multi-jurisdictional. The particular provisions that pertain to cross-section of the jury in special DV jurisdiction cases is important. It requires that there be no systemic exclusion from individuals from juries. And, for many tribes, the jury pools have historically been drawn from enrollment offices and records. And so now tribes are looking at other ways that they can ensure a cross-section of the community. Some tribes are looking at county voter lists, which may require some communication and collaboration between state and tribal officials. Some tribes are looking at including non-Indian lessees in their jury pools. Others are looking at including non-Indian employees. And, with the increase in economic development across Indian country in terms of gaming and industry, we're seeing tribes becoming much more large-scale employers, and that employee base often includes non-Indians. So that is a way that some tribes are looking to meet this cross-section. And just to be clear, too, the cross-section does not require any specific number of individuals be included on a particular jury. It just means that you can excluded solely for race, and that includes looking at your codes and making sure that if there are strikes that are allowed to remove a juror from service, that we are not authorizing those to be made for anything other than race neutral cause. Also on the indigent defense, and I kind of talked briefly about this, but again, the budget costs for tribes when looking at indigent defense has been a big factor. I know that there are some DOJ funding opportunities that might help to support the development of indigent defense programs within tribal communities. I believe that there are some under the CTAS, coordinated. Oh my gosh, I'm not even going to try to say it because now I just went blank and I'm going to forget. So it's the CTAS program announcement that is put out on an annual basis. And there are usually some opportunities in there specific to some of the BJA opportunities that might permit a tribe to access funding that would help to develop some of the indigent defense. But it goes beyond also just the funding, also looking at legal definitions for what will constitute effective assistance of counsel might need to be included in your criminal titles of your code. Also incorporating a procedure for an individual to apply for indigent defense. There may be a need for you to define what indigent will mean within your community, what will be the threshold income base, for example, for an individual to be considered eligible for indigent defense. All of those types of factors are things that are going to impact tribes as they're developing their indigent defense programs or services to meet the TLOA requirements. Another area that I think we've seen a big change in and that has been impacted by the Tribal Law and Order Act and the VAWA 2013 is how tribal prosecutors are reviewing cases and how they're making charging decisions. Typically, one of the first things that a prosecutor will now do is they will look at a case, and if it's a domestic violence related case, one of the first things they're going to have to look at is whether or not this particular case may be subject to special domestic violence jurisdiction. So in other words, we'll be looking at factors such as, do we have a non-Indian defendant? Do we have an Indian victim? Is this a crime occurring with Indian country? And is it a qualifying crime? The next level of their analysis will be if the case is a qualifying crime and the individual is then subject to tribal jurisdiction, they then know that within the tribal justice system, there must be a law-trained judge assigned to the case, and also specific rights must be afforded to the defendant as outlined in the Indian Civil Rights Act provisions that we discussed earlier in today's webinar. Sentencing considerations also need to be taken into account at a much earlier point in time than we had to prior when we were looking at enhanced sentencing authority or the special DV crimes. And the part of the reason is because, again, these different rights attach to these types of crimes, or to these types of sentences. So if we know that the crime that the individual is being charged with is a qualifying crime under special DV jurisdiction, or is a qualifying crime that could where the court can impose an enhanced sentence, then we know that from the onset of that case, we are going to have to afford certain rights to defendants, including the law-trained judge and the indigent defense. So in terms of what constitutes a qualifying crime, these qualifying crimes are outlined specifically in the Indian Civil Rights Act. As for the Violence Against Women Act, you can find the definitions for qualifying crimes under Section 1304C. The qualifying crimes include domestic violence, dating violence, which is an act of domestic violence or dating violence that occurs in Indian country of the participating tribe, and then also violations of a protection order that occur in the Indian country of the participating tribe, and which violate the portions of a protection order that prohibit threatening acts, sexual violence, contact, etc., were issued against the defendant and are enforceable by the participating tribe. So if we meet those specific factors, and we know of a qualifying special domestic violence criminal jurisdiction case, and we know that there are some special rights that will attach. In terms of qualifying offenses for enhanced sentencing authority, what we're looking for here are offenses that is someone who has been previously convicted of the same or a comparable offense by any jurisdiction in the United States, or is a person who is being prosecuted for an offense comparable to an offense that would be punishable by more than a year of imprisonment if prosecuted by the United States, any of the states. And so this last provision for the qualifying crimes is where tribes are really taking a look at how do they define crimes within their tribal codes? What are the elements of their crimes within their tribal code? And then how did those look when compared to existing federal crimes and state crimes? And so we're really looking for, those assault with intent to commit serious bodily injury type crimes, serious assault crimes, aggravated crimes, things of that nature that would normally be considered a felony. And if we meet those definitions, no, that case is now subject to an enhanced sentence, so long as the tribe has all of the required provisions within their tribal justice system. And an important note here is that we've talked a lot about TLOA, and we've talked about VAWA, we've talked about the Indian Civil Rights Act, but I cannot emphasize enough that if we are in a jurisdiction where a tribe is not wanting to impose an enhanced sentence or a special DV jurisdiction, then there is no change and no license require attorney or judges unless the tribe's code or law requires it. Another practical impact that we've had with respect to sentencing pertains to the long-term detention considerations. So when judges are now considering whether to impose an enhanced sentence, something we have to look at is where the individual might be incarcerated. A lot of times the facilities might be federal facilities if there's space available. They might be non-federal facilities, which if that's the case, there may be some requirements for contracts and some compensation may be involved, especially if we're looking at more the privatization field area. But of course, bed space is something that is compensable. And then also what we do know is that a lot of the detention facilities within Indian country have not been updated. There hasn't been a lot of funding for bricks and mortar funds to update. There has been some in recent years for rehabilitation of some detention facilities. But when we're looking at long-term detention, consider that there might be some additional rights for defendants that may not pertain to a more short-term placement. And then also when we're looking at placing individuals farther away from our tribal communities for an extended period of time, it can pose its own series of challenges for post-adjudication measures and in particular for re-entry efforts. So some of those post-adjudication impacts, I think, are that service providers are having to be prepared to work with non-Indian offenders. So that's more on the special domestic violence jurisdiction side. If an individual is convicted of a qualifying DV crime in the tribal court and they're sentenced to a term of jail or fines or probationary supervision, we now have to consider how we're going to work with those individuals. We also need to consider how we're working with defendants in that long-term detention capacity when they're coming back to the community. We know that most re-entry efforts begin while the individual is still incarcerated, and then those efforts back to the community. So part of this is also looking at within the tribal community, what kind of capacity do we have to support some of those individuals and their families when they're coming back to the community in terms of services, in terms of job opportunities. Housing is another big issue, I think, that can be affected, especially if we're looking at some sort of transitional housing where we have an individual coming out of long-term incarceration and there's a period of time that they would be in a transitional housing setting, really taking a look at what's available in transitional housing. And I do know that DOJ has some resources and some programs and funds that are available for tribes to start to look at and assess tribal justice or tribal corrections capacity building. And so that would be something that tribes looking at doing this might want to look into also as part of their justice system planning for ESA and special DV jurisdiction. Probation services, looking at who's going to supervise an inmate after release and how the violations are going to be handled if they occur. And then, of course, with a law that we haven't talked about, sex offender monitoring programs through SORNA, how those programs will be communicating with detention facilities and probation departments that may be from outside of Indian country, especially if we have someone placed outside of our tribal community due to ESA. So that this post-adjudication impact is in part focused on or has forced tribes, I think, to really look at how we're handling people post-conviction within our tribal communities, how we're supervising and developing service for individuals to reduce recidivism, and then also it's really opened the door and impacted how we're going to collaborate and communicate across jurisdictional lines to address reentry and post-adjudication supervision. So for purposes of today's webinar, that's an introduction to the Tribal Law and Order Act, the Violence Against Women Act, Special DV Criminal Jurisdiction. Hopefully you've got your minds thinking a little bit on some of the practical impacts that these laws have had on how justice development, some of the things that we need to consider and maybe look to develop within our tribal communities, and also some of the areas that we may need to consider collaboration across jurisdictional lines. So with that, Travis, I will open it to any questions.
All right, sounds good. We don't have any current questions right now, but feel free if anyone has any questions they wanna ask Michelle or even Julius. We'll leave some questions open here for the next few minutes and try and get you guys some answers. While we're waiting to see if anybody has any questions, I just want to thank everybody for showing up, the guests, Michelle, Parks, and Julius. And I'd also like to take this time to extend an invitation to our next webinar, which will be Working with Victims, which will be presented by Ann Seymour, Senior Advisor at Justice Solutions, and that's going to be on May 23rd. It's a Wednesday. We've been doing these on Thursdays, but that's going to be a May 23rd Wednesday at 2. And we sent the registration for this information for the registration is currently out with CC Headlines, and that's currently also located in the tribal repository on APPA's website as well.
Hello, Travis. I guess while we're waiting on questions, this is Julius. I just wanted to underscore something real quick. That I appreciate Michelle for talking about some of the resources that BJA has available to kind of help out with implementation of TLOA and VAWA. But I want to emphasize that there's the coordinated tribal assistance solicitation, which is the more tribal specific funding stream. But we also have grant opportunities that are not tribal specific that tribes are eligible for. So we've been pushing those out, on our tribal justice and safety website via our, we have a tool where we can send messages to subscribers on our solicitations as they become available. So I really want to encourage people to take a look at our solicitations, because there are ways that you can address, a lot of these issues that Michelle raised, through some of these grants that may not be, tribal specific like CTAS, but could be like we have the Second Chance Act for reentry. We have a grant, comprehensive opioid abuse grant, and so we have so many types of grants that if you look at it, and they may be applicable to your jurisdiction. So.
Looks like we do have one question here. Just wanting to know which states and tribes have implemented TLOA and VAWA so far.
Geez, I don't have my notes printed here, but I know that there are, I can start to name a few. They're all actually specifically listed in that 5-year report that I highlighted in here. But I know that we've got Pasquayaki, we've got Tulalip, we've got Sistan Wapitan. Geez, you know what? If I'm going to just click out of here and go to a presenter view, if that's okay, because then I can pull that up. I have them actually in my notes section here. Oh, there we go. Now everybody's seeing my desktop, I suppose. Oh, here we go. So Pasquayaki, Tulalip, Confederated Tribes of Umatilla, Assiniboine and Sioux Tribes of Fort Peck, Sistan Wapitan, Oyate, Little Traverse Bay Band of Ottawa, Michigan, Cuseta Tribe of Texas, Choctaw Nation in Oklahoma, Eastern Band of Cherokee in North Carolina, Seminole Nation, Oklahoma, Sac and Fox in Oklahoma, Kickapoo Tribe, Oklahoma, the Nottawa, I can never say this, Nottawasepi, that's not right, Huron Band of Potawatomi in Michigan. I apologize to the tribe for misenunciating that. Muskogee Creek in Oklahoma, Standing Rock Sioux Tribe of South Dakota, Sault Ste. Marie of Chippewa in Michigan, Chitimacha Tribe of Louisiana, and the Lower Tribe in Washington.
I think that's it for questions. If no one else has anything, I'd like to thank everybody for their attendance, and hopefully we'll see everyone at the next webinar in a couple weeks.
Thank you.
Thank you, Michelle.
Thank you.